in the matter of Shopping Direct Ltd and others, and VISA Europe Ltd and others.
Yes.
My lords, my lady, I appear with Fiona Banks and Alexandra Littlewood for the appellants. Mark Hoskins QC and Hugo Leith appear for the Mastercard respondents. Brian Kennelly QC and Isabel Buchanan appear for the Visa respondents. The court should have 3 bundles: a core bundle, a supplementary bundle, and an authorities bundle. I apologise, but for the late arrival of a number of additions to the authorities bundle, which I hope have been received, additional tabs 28 to 33 and an amended index, with apologies for their late arrival. They are short, and I hope will be obvious what their relevance is. That as long as the court has those, I'm grateful. This is an appeal from the judgment of Mr. Justice Morgan of the 11th of December 2020 on 2 grounds, and a cross appeal by Visa. The council team have discussed, and subject to the court's agreement, we propose a timetable for this hearing as follows. I'll go first and make submissions on my grounds 1 and 2 for 4 hours, which takes us to about 3:30 this afternoon. The respondents will then make their submissions in response for 4 hours. I believe they've split the time between themselves. Assuming that we sit until 4:15 this afternoon, that takes us until 2:45 tomorrow. I then have an hour for reply, and Visa has 30 minutes to reply on its cross appeal.
You may have agreed that between you. We have also been discussing this. It seems to us this appeal and cross appeal should be dealt with within a day and a half without any difficulty. And we think you should try and tailor your respective cloth accordingly. The issues are pretty short. And over-elaboration is not going to assist the court or indeed your clients. So if you can try and finish the case by lunchtime tomorrow, we would be grateful. But we will certainly sit till 4:15 this afternoon.
Oh, my lord, I'm grateful for the indication. I'll attempt to cut back what I'm going to say as I go along. What I propose to do is make a number of relatively brief, I hope, introductions.
You can assume, Ms. Smith, that we have read judgments and the skeleton arguments and done our homework before we came to court.
My lord, I'm grateful for that indication. So I'll make a brief introduction, if I may, and then address the 2 grounds in turn. So by way of introduction, this case in my submission is about the electronic working pilot and how it applies to the filing, issuing and service of claim forms. In particular, it's about a lacuna, which we say appears in the pilot, which the unusual circumstances of this case have highlighted. As I'll show you, we say there's a mismatch between the approach which was developed under the old case law, based on the operation of a pre-digital court process, and the new electronic process under the pilot. The pilot effectively has given rise to the parties' representatives losing control of part of the process, and as a result has led to there being the potential for practical problems, which we say are in danger of cutting across the recognised benefits that arise from electronic working under the pilot. The pilot is, of course, just that, a trial process, which by definition may illuminate potential problems. We say that this case, this appeal, gives this court an opportunity to clarify the approach which should be taken, so as to ensure that the move from the old system to a new electronic way of working doesn't give rise to unfairness or cause damage to claimants which they would not have suffered under the old system. Of course, the increasing importance of these issues is highlighted by the fact that the piloting continues to be rolled out, most recently to the Queen's Bench District Registries from July of this year, and shortly, we understand, to the Court of Appeal from January now of next year. The lacuna in the pilot, which this case has brought to light, is as follows. There are, we say, 3 steps involved in getting a claim form ready to serve: filing, issuing, and sealing. Before the pilot was introduced, in order to start a case, the claimant's representative would attend court in person, file a document by handing it over the counter and paying the court fee. The registry staff would then issue the claim by sealing it and handing it back. So filing, issuing, and sealing were effectively simultaneous. There was no such thing under the old regime as a claim form that had been issued but not sealed. The pilot breaks this down into a three-step process. Filing happens first when a claimant's representative uploads the document onto CE file. That can be done under the new regime 24/7, 365 days a year. Issuing happens either when the court fee is paid, again electronically 24/7, 365 days a year, or in a case such as this, which was concerned with amended claim forms, there's no fee to be paid, the document is issued as soon as it is successfully uploaded and filed onto the CE file system. So under the pilot, filing and issuing are the same, one and the same thing, effectively. They happen automatically under the system without involvement of the court staff or the registry staff. However, and in clear contrast to the pre-pilot situation, sealing of the claim form happens hours or days later. And it's done by the registry staff, it's not automatic. Crucially, however, the seal that is placed on the claim form will actually show the date of filing and issuing, the previous date, not the date on which the seal is actually placed on the form. So what we say is that prior to the pilot, although we didn't have the convenience of electronic working, there was at least certainty about deadlines. As long as the claimant's representative was through the door of the registry before it shut for the day, the three-step process of filing, issuing and sealing would all happen then and there. By contrast, under the pilot, although the claimant has control over the first two steps of filing and issuing, the claimant's representatives have no control over the time when the seal is placed on the claim form. Sealing takes place at an indeterminate time after filing and issuing, which is outside the claimant's control. Now, this case, and this appeal, is about how the court should deal with a situation where the claimant has filed a claim form within time, the claim form has been issued within time, the claimant is in possession of that issued claim form, but does not yet have a copy with a seal on it at a time when the claimant needs to serve the claim form. Now, it's important to recall in this appeal, although we say it doesn't come through crystal clear from the judgment below, that in this case, all of the amended claim forms had been filed and issued before they were served. And that can be seen from the chronology agreed between the parties, which is at tab 12 of the core bundle. I don't need to take you to it. It shouldn't be in dispute. All the amended claim forms were filed and issued before they were served, even though they hadn't yet been sealed. So for each of the 16 amended claim forms at issue, the claimant's representatives had got through the virtual door before 4:30 on the afternoon of the 17th of July. Each of the amended claim forms had been filed and issued by the close of business on the 17th of July. And before the pilot was introduced, therefore, each of those documents would also have been sealed in time for service by email, which was the agreed method of service, by midnight of that same day, as required under CPR 751. No allegation could have been made that the appellant's representatives were courting disaster, and no argument could have been made that service was defective. Before I move on to develop my arguments under each of the grounds of appeal, in passing, it's important to draw the court's attention to two matters which I think are undisputed, but they do give important context and again don't come through clearly, we say, from the judgment below. First of all, this appeal relates to amended claim forms, not claim forms. So the documents that were served were not the originating process. The claims had already been issued, and each claim had an allocated claim number, which was on the face of the amended claim forms served on the respondents. Further, and this is again clear from the judgment and the evidence on both sides, the respondents' representatives had countersigned correspondence bearing the claim numbers when agreeing various extensions of time for service of the claim forms and lodged that correspondence on the court file. The second important point of context is that the respondents were served not just with cover emails and the amended but unsealed claim forms, but also a 30-page particulars of claim, setting out the claimant's case in some detail, together with quantum schedules itemising the damage alleged, and a full response pack. For your note, an example of the Visa particulars of claim is at the core bundle tab 19, and an example of the Mastercard particulars of claim, core bundle tab 29. So, moving on to our two grounds of appeal, I'll summarise our position and then develop it by reference to the case law. Under ground one, our case is as follows. There is no requirement, explicitly under the CPRs themselves, that a claim form, let alone an amended claim form, has to be sealed before service. The judge below and the respondents on appeal rely on the general rule, in quotation marks, set out in the case law, specifically a judgment in Hills, which I will show you. But we say that judgment cannot be applied to the facts of this case, but in an event is no longer good law, and should not be applied to the situation after the introduction of the pilot. We say further that when properly read in context, the Practice Direction 51.0, that's the Practice Direction for Electronic Working under the pilot, including in particular paragraph 8.1 of that Practice Direction, does not impose a requirement that a claim form that has been filed and issued must be sealed before service. Nor does it set out a requirement that service of a filed and issued but unsealed claim form does not constitute service for the purposes of the rules. If we say, contrary to that primary submission, there is such a requirement arising from paragraph 8.1 of the Practice Direction, this amounts to a defective procedural step which can and should be remedied under Rule 310 of the CPRs. And that is our appeal under ground 2. Our case under ground 2 is that service by the appellants representatives of amended claim forms in time and by a method which had been previously agreed with the respondents' representatives, but which were unsealed, is an error of procedure for the purposes of 310, Rule 310, which can and should, in the circumstances of this case, be remedied by the court. So turning then to ground 1 and the judge's judgment, I'll deal with as briefly as I can. It's in core bundle tab 14. And your lordship has kindly indicated that you've done your homework, so I'm not going to read out the judgment, but the relevant part of Mr. Justice Morgan's judgment for the purposes of ground 1 starts on paragraph 48, which is page 184 of the bundle, and goes through to paragraph 61. Sorry, paragraph 58, in fact, not 61, 58.
Yep.
Paragraphs 48 to 58. I'll summarise his judgment in that regard. In essence, the judge found that for the purposes of CPR rules 631 and 75, claim form, in quotation marks, means a sealed claim form. And and he relied on the judgment in a case called Hills, which I'll take you to, a High Court judgment, and the Court of Appeal judgment in Cranfield in this regard. The judge held in paragraph 58 of his judgment that what was served by the appellants on the 17th of July, because they were unsealed, were not claim forms for the purposes of the rules, and therefore no valid service had been effected in time. We say, obviously, the judge erred in reaching that conclusion. The respondents say he was correct. The respondents say, and I summarise, the general rules set out in Hills should be applied in this case. This rule is not displaced by the introduction of the pilot. In fact, paragraph 8.1 of the practice direction confirms the need to serve a sealed claim form. The service of a sealed claim form is necessary to achieve the objective of giving a clear message to the defendants a claim has been issued against them, and it's not just some informal demand. And they say finally that this approach does not give rise to practical problems even under the pilot, or they say any alleged uncertainty cannot justify departing from the long-standing rule that valid service may only be effected by means of a sealed claim form. So I'll address each of those points in turn. First, what the CPRs actually require. Second, what the process was under the CPR and what's now under the pilot. I can deal with that briefly because I've already outlined that. Third, the general rules set out in Hills and the notes to the White Book. Fourth, the objective of the rules, and finally, the practical difficulties and uncertainties. So if I can ask you to turn and look first at the CPR rules themselves, which are in the authorities bundle at tab 24. If I could ask you to turn to the first page behind tab 24, which is page 476 of the bundle, Rule 261, which says that court documents must be sealed on issue, including the claim form. And then Rule 263, and a document purporting to bear the court's seal shall be admissible in evidence without further proof. So I make the following points on that rule. First of all, the rule appears to envisage issuing and sealing to be simultaneous. That is, the documents the claim for shall be sealed on issue. Obviously, the rule says that a seal can be placed on a document electronically, which is what now is usually done. But what's also important to note in my submission is that subparagraph 3 sets out the purpose of sealing. That is, that a sealed document is admissible in evidence without further proof. Overrides the general rule, which is set out in the notes of 263. There is no indication on the face of that rule. I think it's pretty obvious that a seal must be placed on the document before service. Obviously, there's no mention of service at all in that rule. It's just about issuing. Over the page on 477 is Rule 310, which I'll come back to. Underground one, I'd like to look first at the rules on service, which are contained in Part 6 on page 478. First of all, Rule 6.1a, which sets out the part applies to service of documents except where another part or a practice direction makes different provision or the court orders otherwise. 6.2c, this is the only definition insofar as it can be described as such of claim form in the rules. 6.2c says that claim includes petition and any application made before action, etc., and claim form, etc., to be construed accordingly. So not really a definition, but it's the only indication of what claim form means. Yeah. The most important rule, or the one that was specifically at issue in the present case, is on page 480, which is 631b, which sets out methods of service. And 631b says a claim form may be served by fax or other means of electronic communication in accordance with Practice Direction 6a. Yep. Just by way of comment there's no suggestion that Practice Direction was not complied with in the present case. The only defect was the fact that the claim form was unsealed. The issued claim forms, unamended claim forms were unsealed. The respondents and the judge below relies on the notes in the White Book at para 632 on page 481, which you'll see the heading Service of Original Sealed Claim Form Generally Required. If I could just ask your Lordships and your Ladyship to read that.
Yeah. Let's do that.
My Lord, our submission on these notes is that they simply record relevant case law, most specifically the judgment of Mr. Justice Ramsey in Hills. We say obviously that's not binding on your Lordship, and I will show you why we say that is no longer good law after the introduction of the pilot. Then if I could ask you, my Lords, to flick over the next 2 pages, past Rules 615, which is service by an alternative method, and 616, power of the court to dispense with service. And then if I could ask you to focus on part 7 of the CPR, which starts on page 485, which is the rules on starting proceedings. Rule 7.2 on page 485 is how to start proceedings. Proceedings are started when the court issues a claim form at the request of the claimant. The claim form is issued on the date entered on the form by the court. Then Rule 7.5 on page 486 deals with time for service of a claim form, and you'll be familiar with the fact that 7.5.1, where the claim form is served within the jurisdiction, you must complete the step required before midnight, 4 months after date of issue, and here sending the email. And then over the page on page 487, Rule 7.6 makes provision for extension of time for serving a claim form. And such an application can be made under 7.6.2 either before the expiry of the time for service, or under 7.6.3 now, after expiry of the time for service. So my submissions on the rules are as follows. We see that Rule 6.3 provides, well, these rules so far, 6.3 provides for the method of service, 7.5.1 provides that a claim form must be served within a particular time. Neither of those rules provides that the claim form which is to be served must be a sealed claim form.
that may be because under the traditional method, if I can put it that way, of issuing, you wouldn't actually have an issued claim form unless it were sealed.
Well, that's exactly my point, my lord. That's exactly my point. That it's clear that the rules
So
and the case law...
The rules are actually silent on sealing because issue and sealing are simultaneous.
They're silent on sealing because under the old rules, or under the old process, we say, there was no clear distinction, at least as a matter of time, between those steps. Although the rules do, we say, recognise the three-step process, the rules themselves, the CPR rules of filing, issuing and service. It's just that they always happened simultaneously under the old regime. For completeness, can I just ask you to look, while we're there, at CPR Part 17, which is on page 490. And that, those are the provisions about amending statements of case. And Rule 17.1.1 has particular relevance in the present case. It provides that a party may amend his statement of case at any time before it has been served on any other party. And that is what happened here. And such amendments can be made without permission of the court or consent of the other parties, without an application. Interesting, my lord, in light of your comment just now, to look at the notes to the White Book 17.11, the very last paragraph on that page 490, the first sentence. The right to amend without consent or permission arises only in respect of statements of case which are filed but not served. So there's a distinction there between the filing and...
Sorry, which?
I'm sorry, bottom of page 490.
Yeah, sorry.
Last sentence, last paragraph, first sentence, which starts accordingly. The right to amend without consent or permission arises only in respect of statements of case which are filed but not served. So the distinction there is made between filing, and we say, plus issuing, and service. So,
again, under the traditional way of doing things, what would have happened is that the claim form would have been issued and sealed, and then the claimant would amend the claim form in red. But what would be amended would be the sealed document.
because the issuing and sealing
So it's
were
only ever
simultaneous,
sealed,
handed back
yeah.
over the counter, yeah.
Which you could in fact have done here.
No, we could not.
You could not have done that.
No, because the electronic filing pilot was compulsory in a case where legal representatives were involved
So you
in
couldn't,
the
you
roles
couldn't,
building
you couldn't simply
jurisdictions.
have amended the existing claim form in red.
We understood
Couldn't
that
you have done that electronically?
an amended claim form, yes, had to be filed.
You
and
could have
issued.
done that electronically and filed that electronically. And if you'd served that document, then we probably wouldn't be here today.
Possibly, but the rules practice direction under Part 17 provides that the amendments do not need to be marked. They do not need to be underlined. I'll get you the exact reference for that. And what we in fact served were the amended claim forms with the issue numbers on them that had been amended.
What you did, this isn't intended to be critical. It's just exploring what
Yeah.
happened. You had alternative courses. One is to amend the existing sealed claim form as it were, in red, or by underlining, which you could in fact have done electronically, I think. Or what you actually did, which is to file with the CE file, as it were, a new document that had your amendments in it, but it wasn't by way of red lining or underlining.
I would have to check the actual.
If we look at the claim forms that were issued, the one at tab 17, I think, is one, isn't it? Example.
Yes.
It's headed amended claim form under CPR rule 17.1 dated 17th July.
Yes. Yes.
But if you look at it, it doesn't have any underlining or crossing out.
No.
But in fact, the claim under Article 102 has been abandoned. So
That's right.
in a traditional way, you'd have seen on the face of the claim form that claim crossed out.
Yes. You could have done that with a pen. If I could take you back to the CPRs, the White Book notes on practices, proper practice on amendment, page 491.
Yeah.
Page 491, paragraph notes 17.1.2, under the heading Practice on Amendment. A party amending their statement of case is not required to retain the superseded text in the amended document unless the court directs them to do so. But then it's also important to note what comes after those two subparagraphs 1 and 2. A statement of case amended without permission must be endorsed as follows and should be filed as well as served. So my point that I wanted to make is that it's not enough to simply download what had been on CE file, the original claim form, make some amendments in it in red and serve that. You have to file the amended claim form as well as serving it. So we filed it and then served it in line with this guidance. The court then sealed it a few days later. And what we're being told is that the service before it was sealed was not good service.
Is it your case that you couldn't have done what 17.1.2, what that note contemplates, either 1 or 2? I can see 1 like
Oh no, we
couldn't have done that on CE file. Couldn't have.
I have to check whether you can do a red
Produce
underlining
a
on a
document
computer.
with a different typeface.
I'm not sure. I'd have to check that.
I'd be surprised if you couldn't.
No,
I understand the point
maybe
about
that.
not being able to do it in red or
Yeah.
whatever.
I mean, those may have been options, but they are just that, options.
All right. Yeah, sorry, Mr. Smith.
No, my lord. So, my lord, just the two points that I want to make on the CPR rules before we move to the case law. And I think I've already made these points. Filing, issuing, and sealing have always been three separate steps, and that can be seen from the CPR themselves. Rule 721 says the proceedings are started when the claim issues the claim form at the request of the claimant, so the request of the claimant is a filing. Rule 722 says the claim form is issued on the date entered on the form by the court, so that's the issuing, and 26 says the court must seal. We make the point, and this is an important one, that sealing is a subsequent third step that simply confirms the separate and earlier act of issuing.
I'm sorry, Ms. Smith.
Yes.
You referred to 7.21 and used the word file. That's not in 7.2.
It's not. I accept that, my lord. It's not in.
The term filing is actually appeared in any of the rules you're skipping.
It's not. No, it may very well not be on the wording used on the rules themselves. It's certainly in practice directions, notes, etc. But it's not. You are absolutely right. It's not in the rules themselves. But then even now, after the pilot, filing and issuing is essentially simultaneous. But obviously you put it in and it comes out, you file and it's issued. The second point is, and I've made the point, there's no explicit requirement in the CPR for a claim form to be sealed before it's being served, and that point is even stronger as regards amended claim forms where there's no requirement for sealing at all, or is a requirement for filing. So if I could then ask you to turn to the process under the pilot, which is in the practice direction, Authorities Bundle tab 25. And if I could start with paragraph 2.1 on page 494. That simply makes the point, paragraph 2.9, that this is a 24-hour-a-day, 365-day a year process. On page 496, if I could ask you to look at paragraphs 5, 3, 1 and 2, those are sidelined at the bottom of page 496. If I could ask you to read those paragraphs. And if I could ask you to turn over to page 497, and then if I could ask you to read again the sidelined passages, paragraphs 5, 4, 1 to 6. And then, my lord, my lady, if I could ask you to look at page 498 and electronic sealing. Sorry, my lord.
In the context of just focusing on acceptance for a moment,
Yes.
that this is, as it were, an electronic version of what happens under the old method, the old ways of working. If you turned up at the counter with a claim form that, for whatever reason, was defective, the court staff might refuse to issue it.
Yes.
And there might be situations in which you could persuade the court staff to issue it because an error could be overlooked for whatever reason, could be remedied for whatever reason. But usually what happens, you'd be sent away, the outdoor clerk would be sent away with a flea in his or her ear and told to come back
Yes.
tomorrow with the right document.
Yes.
And this is just as it were, an electronic version of that concept, isn't it?
To a certain extent.
None of it's valid until it's accepted.
Yes, my lord. But there are a number of points to be made on that. First of all, under the old regime, if there were no problems, you would have had the document sealed immediately. So acceptance would have taken place immediately. Under the pilot, that does not happen, and I'll show you the timing. At the very best, the aim is that it's done within 90 minutes. That did not happen in any of the cases here. Second point of importance is that under the old regime, if there was a problem that meant the document could not be sealed, you knew it immediately. So if it was simply a problem that you hadn't underlined in the right colour, you could go away and rectify that immediately. Under the pilot, you don't know immediately, because it takes some time for the document to be drawn off the system, looked at by the court staff, and a notice be sent back. And third and final point is that in none of these cases, in none of the claim forms in this case, was there any problem, and in none of them was acceptance refused. In all of them, the documents were accepted as they stood. There was no problem with acceptance. There was one case where a judge came back, a master came back and said, don't you have to underline? The solicitor said, no, we don't under the new rules. He said, oh, okay, sorry, I was wrong. And then it was accepted. But in none of the claim forms in this case was there any problem. Was acceptance refused. So, but nevertheless, it took a number of days for the claim forms to be accepted, the amended claim forms to be accepted. So, if I could then ask you to look at paragraph 7.1 on page 498, which deals with electronic sealing. And this is what comes back when the documents have been accepted with a capital A.
Yeah.
And then paragraph 8.1, which is about service. So I make the following submissions on the position now under the pilot. Under the pilot, parties can issue proceedings 24/7, 365 days a year, and that's obviously a major change and a key benefit of e-filing. As I've said, instead of the 3 steps of issuing, filing and sealing happening in such immediate succession as to appear to be a single step to the claimant, they're split out. The claim form is filed electronically using a CE file. And at that stage, an automated notification email is generated by the CE file, confirming the time of filing to the user. And you'll see the specific times in the chronology at tab 12 of the core bundle where that automated notification email was the time that it was generated. So that confirms the date of filing.
The point of detail, does it confirm the date of filing or the date of submission?
It says,
Have we got a copy of the...
I'll see if I can find a copy. I think there's one attached to the third witness statement.
Might be in the supplementary bundle, I suppose.
Yes. Sorry, it will be in the exhibits. I'll just have to find someone to dig one out if I may, my lord.
Yeah.
We'll come back to it.
Well, maybe we'll come back to it. See if one of your juniors can find it. That'd be helpful. Just so we can see it.
Yes.
Yep.
And as if by magic, I have it immediately.
There we are.
I know, very impressed. They're worth the money. Supplementary bundle, tab 44, page 220.
220.
Is that the first one?
That's the acceptance, isn't it?
Is that the
that's the approval of the, that's not the automatically generated one.
Sorry, they're not worth
Don't
money.
worry, don't worry. Let's, it's the sort of document that-
I'm assisted by Mr. Hoskins with the text, and we'll see if we can find an actual example of the email. But the text is set out in Ms. Holloway's third statement below, which was in Supplementary Bundle tab 12,
Yeah.
page 148,
Sorry, 12.
12, paragraph 12E.
Yeah.
I'm
That's what I
sorry,
thought.
yeah, and
Had been
an
submitted.
example of that is in the Supplementary Bundle tab 41.
I think that was the point my lord was putting to you, that technically it's, or perhaps more accurately described as submitting.
Yes, you're right, my lord. The words of the automatic notification email, tab 41 of the supplementary bundle. This is a notice to inform you that the filings, confirmation number, etc., have been submitted on 15th of September, in this case, 4:23 p.m. You can view the filings here.
Yeah.
So it refers to the filing and to the filing having been submitted. So practice direction, paragraphs 542 and 543 state the date and payment of the court fee, where applicable, will be the date and time of issue. But where no court fee is payable, the date and time of filing will be the submission date. And filing and issuing become essentially the same step. The point there is that it can be that step, the filing and issuing or the submission, can be undertaken at any time outside court hours, but it's also entirely within the claimant's representative's control. The next stage is that the claim form is reviewed by court staff, who, as you say, either accept the filing, reject it, or provide comments. If they accept, a sealed version becomes available on CE file for download, and you've seen the notification supplementary bundle tab 44 of that. And that automated notification email is generated. That step is not within the control of the claimant's representatives, because it requires court's registry staff to look at and accept the filing. However, as I've said, whenever the acceptance takes place, the seal actually bears the date and time of the filing and issuing rather than the date and time of acceptance. So it can be the seal on its face, and we'll see this from the case I'm going to take you to, City Sprint, will bear the earlier date, even if it's 2 or 3 days before the seal was electronically imposed upon the electronic document and acceptance took place. Now, how long does that take, this process, this second stage? The Roles Building Courts Charter, which I'll take you to, which is in the Supplementary Bundle tab 80.
Tab
80, right at the back. Page 287. And this is the roles building, because this is the jurisdiction we were under in these cases. The Court's Charter, page 287, indicates the second bullet point. Originating processes, etc., will be accepted not more than 90 minutes from the time the document is submitted during working hours. Following bullet point, all other documents, including consent orders, no more than 3 hours. So that's the aim, but so that's the aim of the staff, but in these appeals, none of the filings of the amended claim forms were accepted within 3 hours. Most were filed on Friday the 17th of July throughout the course of the day, starting at about 9 o'clock, and the last one was filed at 4:18 in the afternoon.
You wouldn't have expected that one to be dealt with within 90 minutes of 4:18. That could never have been
Not
dealt
under
with
the
until
new, no,
Monday at some
no,
point.
it wouldn't have been. But they weren't, none of them except one, I think, that was lodged in at the beginning of the morning.
But your solicitor accepts all this. She accepts that she knew that because of the pandemic, this wasn't being. I mean, this was all laid down before the pandemic.
Yes.
During the pandemic, there were staff shortages. There were all sorts of things going on.
Yes.
The 90 minutes wasn't complied with
No.
on a regular basis, and the solicitors who practice in these courts knew that, including your solicitor.
I think that's correct,
She
yes.
says that in her
Yes,
one of her
yes.
witness statements. And the short answer to all of this is, if you'd done all this a week earlier than you did, then none of this would have been a problem.
That is one answer to it. The other answer is, if you had done this before the pilot, there would have been no problem at all. You turned up to court before the pilot. But that is the point. My lord,
It goes back to the old point that, you know, I can remember being involved in cases when I was at the bar when it would transpire that the solicitors had sent the outdoor clerk down to the court to get a document issued and sealed by 4:30, and it got there and the court was closed, and that was a risk that you took. If there was your taxi from the city or your fast runner from the city couldn't get there on time, tough. The answer was you did it the day before or a week before or a month before. Anyway, we were on the 90-minute point. I understand the point, Ms. Smith, but I'm not sure.
Well, there is one point I would like to make, my lord, which is, under the old system, if that happened, for example, the clerk didn't get to the door of the court by 4:30, you knew that immediately.
Oh, yeah,
And you could have served the original claim form, and then, which was sealed in this case, and then subsequently served the amended claim form. However, the point is,
you could have done that on the afternoon of the 17th of July, when you knew
we
by
could
that
have,
stage.
well, my lord, one could have. Miss Holway frankly says, yes, she could have done that. And to be fair to them, the respondents say, had they done, we asked them, they would have accepted that. What she says is that she did not, perhaps mistakenly, understand that to be necessary when she had filed and issued amended claim forms which superseded the original claim forms. She had the filed and issued amended claim forms, confirmation from the court that they had been filed and issued, and those amended claim forms which superseded the previous claim forms and were different, as your lordship appreciates, in scope.
She had, sorry, picking up on my lord's point just then, you said she had confirmation they were filed and issued. She didn't. She had confirmation they'd been submitted.
My lord, I apologise. She had
Therefore
confirmation
filed.
they had been submitted and filed.
They'd been submitted and filed, but knew that they hadn't been issued because they hadn't been accepted.
No, my lord, no. And this is an extremely important point with respect. The rules in the CPR and the practice direction make it clear that issuing occurs at the date of filing or submission.
But only after acceptance.
No, my lord, no. And that is sorry, no.
Retrospectively.
With respect, that's not how we read the rules. Let me.
Well, 541, let's look at the sort of basic position, if I put it that way, Ms. Smith.
Yes.
Where payment of a court fee is required to accompany the filing of a document, the date and time of filing will be deemed to be the date and time on which the payment of the court fee is made.
Yes.
So it's a deeming provision, and then 542, date and time of payment will also be the date and time of issue.
Yes.
So they're all deeming provisions, and they're deeming provisions because the reality is that until they're accepted, it's always possible that back comes a message this hasn't been accepted, in which case you haven't issued.
Oh,
True, it is the date that it's backdated, so the date of issue on the claim form, as reflected in the seal for that date, would have been the 17th of July. But I'm not sure you can say that it's actually been issued under these.
well, my lord, we
As opposed
do,
to
we would all,
deemed dates, really.
well, my lord, as well, it's important to look at 543,
Yeah.
which is all other document filings, including the filings in the present case, because no fees were payable on the amended claim forms. The date and time of filing will be the submission date and time.
Well, that's only talking about filing, isn't it? Not
Yes,
talking
and
about
then
issuing.
you read back the date and time of filing. And then you read subparagraph 5. The date and time of issue or the date and time of filing will not be delayed by acceptance unless the submission fails acceptance. So if, as in this case, they are subsequently accepted, the documents are held to have been filed and issued on the date of submission.
Yes, but if you don't know they've been accepted, you don't know that they've been filed and issued. Which is what where this conversation started, was what you said to us was that the person who had submitted the documents knew that they had been filed and issued, and I don't accept that that's correct. No, because they'd been submitted.
Yes,
and
my
it's
lord,
also known is that if they were accepted, then that would have been the date on which they were filed and issued.
my lord,
That's
yes,
not
I apologise. Subject to acceptance, they knew they'd been filed and issued.
subject to an acceptance which they know they didn't control.
Yes.
Something the court had to do.
I make again the point I've made before, that, yes, under the old regime you would have known whether or not there was a problem with acceptance.
It comes back to the 90-minute rule, doesn't it? That you know, if you leave it till the last minute, you know that there may be a glitch, because for whatever reason the claim form may not be accepted. The amended claim form may not be accepted. However confident you are you got it right, people get things wrong, don't they?
Yes, my lord. And I suppose the point is, if you knew that there was a problem, what are the alternatives? Serving the original sealed claim form, which has now been and will, in effect, superseded
Yeah.
by the amended claim form, or serving the amended unsealed claim form. And we say either serving the amended unsealed claim form was valid service for the purposes of Rule 6.3 and 7.5, or it was in the nature of a procedural error that can and should be remedied under 310. So if I can take you then, my lord and lady, to the cases upon which the judge and the respondents rely, which is start with Hills, which is an authorities bundle tab 10. And just by way of introduction, in that case, a photocopy of a sealed claim form was sent to the defendants. Claimant did not follow up that claim form with the particulars within 14 days, so the defendant obtained an order from the court striking out the claim under CPR Rule 741B, and the claimant applied, in that case, to set aside the order on the basis that the 14-day time limit had not started to run because they had not made valid service of the claim form, because they sent a copy of the claim form rather than the original. So unusually it was the claimant who was arguing that they had not validly effected service. And that, in my submission, did affect the way in which the judge approached the case. But if I can ask you to turn first to paragraphs 38 to 40 of the judgment on page 169. And ask you to read 38 to 40 on page 169.
Yeah.
Then the judge refers to exceptions to that rule in paragraph 41, and that is obviously when a claim form is served by fax or other means of electronic communication.
But he's dealing there with a slightly different point.
He is, this is my point, my
Dealing
lord.
with a point that what was served was a photocopy or a copy attached to an email or whatever. That wasn't the original.
Yes, well in fact it
But
wasn't
still had a
attached to an
seal.
email
It
because
still had a seal on it though.
my lord, yes. I understand that was the case, and it wasn't attached to an email, of course, because had it been attached to an email, that would have been fine.
Sorry,
It was a photocopy in a
If
letter.
it had been sent by fax.
Yes,
I'm
yes.
not sure anybody serves anything by
No.
fax these days, but possibly if it had been sent by fax, then what would have been sent would have been an electronic copy that had a seal on it in the sense you could see
Yeah.
it with a picture of the seal. But it wasn't, because it wasn't the original with the seal on it, it wasn't good service. That was the point.
Even by fax, it would have been good service. The
If-
fact it was a
if-
photocopy that was
yeah,
in a letter. If anything ever, if it happens at all
But
like
it
that
doesn't,
anymore, I
but
don't think it
paragraph
does.
41 doesn't impinge on the necessity for sealing.
Well, my
It
lord,
impinges on whether you have to serve the original with the seal.
original versus copy.
Yeah.
And the case is referred to by the judge in paragraph 42, Weston and Bates, and in paragraph 43, Cranfield, were again concerned only with that point, the distinction between an original and a photocopy. And then if you can look at paragraphs, I could ask you to read paragraphs 45 through to 48, where he reaches the conclusion in 48. So I make two submissions on this case. First, the judge in Hills was not concerned with the difference between a sealed and an unsealed claim form. He was concerned with the difference between a copy and an original of a sealed claim form. The cases he considered, Weston and Cranfield, were also about copies versus originals. Under the electronic pilot, obviously all sealed documents are now produced electronically. There's no longer any concept of a copy versus an original. As I understand it, the electronic sealed version can be downloaded from the CE file a number of times. So my first submission is that Hills should be confined to its facts, and that what those were, that where the rules required service of an original document before the introduction of the pilot, a copy will not suffice. My second point is that if, as the respondents seek to do, and as the judge below did, paragraphs 40 and 45 of the judgment in Hills should be read more broadly, so as to impose, so as to mean that the rules should be read, or the reference to claim form under 7.2.2.6 and 6.3 of the rules should be read as meaning a document which is sealed. We say obviously that judgment's not binding on this court, but in any event, we say that the procedural, or the factual basis, apologies, the factual basis upon which the judge was proceeding in that case was one where there was no distinction between issuing and sealing. That's paragraphs 40 and 45 of his judgment. And he did not have in mind, in my submission, a situation where there is a time lag between filing and issuing and sealing. For completeness, I just need to also take your lordships to the Court of Appeal judgment in Cranfield, which Mr. Justice Morgan relied on in the judgment below. That's it, and I'll do that as quickly as I can. That's at tab 5 of the authorities bundle. The judge below relied on paragraph 87 of that judgment, which is at page 66. And the relevant part of long paragraph 86 is the section at the bottom of that paragraph, just above G, which starts the only flaw in the process. So if I could ask you to read from that to the end of the paragraph. The only flaw in the process was that Horwich sent a copy of the issued claim form rather than the original document itself. So if I could ask you to read that to the end of paragraph 87 and also paragraph 88. So just make the following point. The only defect identified in that case was that a copy of the claim form was served rather than an original. There is only reference to an issued claim form, no reference one way or the other as to whether or not it was sealed. I assume it would have been because it had been issued. Under the old regime, it would have been sealed. And in paragraph 88, in any event, the judge said if it had been necessary, he would have decided to dispense with service in any event. So in my submission, that really adds nothing to the judgment in Hills and says nothing about the requirement to seal a claim form. So as I've said, both Hills and Cranfield predate the introduction of the pilot. Visa and Mastercard, however, both rely on the fact that the general rules set out in Hills, as they see it, that is that a claim form needs to be sealed before service, was applied by the judge in a case called Dory, which postdates the introduction of electronic filing under the pilot. So I should take you to that. It's in tab 16 of the authorities bundle. Tab 16 of the authorities bundle, that's a judgment of the Honourable Mr. Justice Bryan, and the facts are set out in paragraphs 24 and 25 on page 296. In summary, a claim form was served on the defendant in analogous situation to the present one, which had been filed and issued under the CE filing. But there was no court seal or claim number on its face. You can see that in paragraph 24. The claim form does, under the heading claim number and issue date, have a claim or number or issue date completed. These are our amended claim forms, of course, did have claim numbers on them, but it doesn't bear, nor does it bear a seal. But it is signed with a statement of truth, as were the amended statements of claim in the present case. Equally, the particulars claim do not have a claim number attached to them. Ours do, of course, but accompanying those documents was a document entitled E-Filing Submission Confirmation. So that's the email that we have seen. So from paragraph 25, from this it would be apparent a claim form had been CE filed and issued that day. I should say the time, the date is 14th of November and the time 4:19 p.m. So in other words, shortly before the letter accompanying the claim form was handed to the guarantor's solicitors. And if I could ask you, and I would highlight, and we rely upon what the judge says in paragraphs 26 and 27. So if I could ask you to read what's in paragraphs 26 and 27 of the judgment.
And that's on the basis that, leaving aside for the moment acceptance and sealing, is this right?
Yes.
Once it's filed, it gets a claim number.
And yes, he says, they could have confirmed, as he put it, that indeed a claim form had been issued. And if they had looked at that, they would have been able to see it was in identical terms to that which had been served, and they would have been able to identify the claim reference number. And he says, it's a reasonable inference, I'm satisfied that that is what a solicitor would do in the position of Waterston Hicks. So they could go on to the CE file system, put in a search term, the name of the case, find
That wasn't necessary here because the amended claim forms already had the claim numbers that the original claim forms had been allocated, the original claims had been allocated.
Absolutely, my lord. But if there were any question, and that this was a point that was not accepted by the other side below, if there was any question that these claim forms had been filed and submitted, and we say issued, before they were served, the defendants below said that they would not accept that they had that knowledge. That could have been checked by looking on the CE file system.
Well, if these had been original claim forms that you were serving and you hadn't yet had them accepted, and you'd served what you'd filed, which is what happened in this case, is that right? Then defendant solicitors could have looked up, when they were served on the afternoon of the 17th of July, they could have looked up on CE file and seen that these had been issued, or so they've been filed that day.
In fact, yes, it was slightly more complicated in this case, in that the original claim forms had been issued.
Yeah, I'm just looking at
Filed
what
and
the position would have been
accepted.
if they had been original rather than amended.
Yes. But what we had in this case were original claim forms issued, filed and sealed some months, if not years, before the amended claim forms were produced, not served on the respondents, but sent to them for information with a seal on them. So they had, the original claim forms had been issued, filed and accepted and sealed, sent to the respondents for information, and on the back of that, the sending of those original sealed claim forms, the respondents agreed to extensions of time for service. In some cases, on a number of occasions.
Forgive me, can I understand the facts of this case,
Yes.
but which we're deciding, but I haven't quite understood Dory at the moment. What paragraph 24 of the judgment says, it refers to the email which confirms submission.
Yes.
Then it is said in 25 and 26, 25 says it's apparent that the claim form had been filed and issued. Does that mean that in the Dory case, not only had the material been submitted, but it had been accepted?
No. Because had it been,
Okay. In which case, with great respect to Mr. Justice Bryan, I'm not sure that he's right in paragraph 26.
Well, that's why
I'll be corrected, but
That's
that's
exactly why I asked the question as
I-
to whether when the document is, if you're looking at an original, let's just look at an original claim form that you file on CE file on the afternoon of the 17th of July. It's yet to be accepted. If, for whatever reason, the defendant solicitors had looked up on CE file at that time, would they have seen a claim number allocated to it? That's why I asked the question, because I think that it doesn't get a claim number until it's accepted, for obvious reasons. Otherwise, potentially the system's clogged up by
yes. I
bad claim forms.
would double check that point. Looking at the email, that we have an example email of a filing confirmation, which is at supplementary bundle tab 41.
Yeah.
So this is unfortunately it's a subsequent case, but not one of the ones that was the 17th of July. But the email goes to the party who submitted the filing with a confirmation number, and you can view the filings here. So there's a hyperlink to take you through to the filing. As I understand it, any other party can also go on CE file and see the filing.
Well,
What I am not sure of, and what I will check, is whether that filing has a claim number
The
attached
difficulty
to it.
here, if you look at the subject on this, it says external filing submission case number CP 2018 quadruple 028. That's because the original claim forms
Had
had
already
been accepted.
Yes,
But
my lord, yes.
I think what we're both asking
Exactly.
is, if you've got this
And I
email
will-
for an original claim form where you hadn't yet had an acceptance, would it have a claim number? I'm very
I
much doubting.
have to admit, I do not know the answer to that question, and I will seek to get instructions on that particular question. All I know is that you would have been able to see that a document had been filed.
You certainly could have seen that it had been filed.
Yes.
in front of you.
Whether that immediately
At
gets...
the moment, but just to be clear,
Yes,
I know that the filer can tell that a document, I really wish we would use the word submitted. I understand it's your case that is the same as filing, but I think it would help.
my lord.
I understand that the submitter can see what they've submitted, but it's certainly not intuitively obvious to me, let's put it that way, that anyone else can see what has been submitted if it hasn't been accepted. I didn't think they could, I may be
I'll take instructions on that, sir, my lord. So, my lord, if I can just, while we're on the case of Dory, ask you to look for completeness at, first of all, on page 301, paragraph 56, where he makes the same point that we've been discussing. And also he makes the same point in paragraph 60 on the facing page 302. And then if I can ask your lordship,
That's what we're both querying, is whether it's actually right.
I understand the point, my lord. And I'll try to come back to you as soon as I can
It
on
may
that.
not matter for the issue as to whether this case is rightly or wrongly decided. Yeah.
Yes, my lord. If I could then
And
ask,
this is a case where the judge did or didn't allow a remedy under 310.
he did allow a remedy under
Did,
310,
yeah.
my lord, yes. The respondents rely upon this case because they say that in paragraph 70, which I'd like to take you to now,
70.
yes, on page 303, this is the section of the judgment where the judge considers the application under Rule 310. And then the respondents rely upon paragraph 70. Because they say, I could ask you just to read paragraph 70 and I'll make my submission. And if I could actually ask you to read 71 as well while you're there. Oh, and I'm asked if you could look at 72 as well, please. So,
Just a moment.
yes, my lord.
Yeah, if you look at yeah, 72 is puzzling because 72 says it would have taken a matter of minutes, if not seconds, for the guarantor solicitor to access CIFA, locate the very same claim form sealed and the associated
Yes.
claim reference number. So it looks as though this was a case in which the claim form had in fact been not only submitted and issued, but accepted and therefore sealed, but what the claimant solicitors did was to serve by email an unsealed claim form, even though there was a sealed claim form in existence. which could have been located on a CE file.
Yes.
So actually, the points that we were putting to you may not be valid because the judge may have said what he said at 24 to 27 and later on the basis that it was a sealed claim form. So he's not saying that you get a reference number simply by submitting. You only get a reference number when it was sealed, when it was accepted. So.
Yes.
And you can see why, at least potentially, 310 might apply in Dory, because there was a sealed claim form in existence, and the error was serving an unsealed claim form as opposed to a sealed claim form. Really, there was one.
Well, my lord, that may have been the case, but I think that word sealed in brackets is the only reference to the existence of there being a sealed claim form, and it certainly did not form any part of the judge's reasoning under Rule 310 as to why.
No, I mean, it may be that we could actually find out by going to see.
My lord, and it's not clear.
At least my lord and I could find out by going to see. I'm not sure you could, but
I probably could have done as well. Yeah, I had not picked
the
up.
£10,000 fee might be a bit.
Yeah, a bit much for that. I have to admit I hadn't picked up the words in the brackets before now because that word sealed, the existence of a sealed claim form
the answer to all of this
does not.
conundrum may be if one of your juniors can confirm, or your solicitors can confirm or otherwise, whether you get a claim number when you file, or you only get a claim number when it's accepted. I suspect it's the latter.
We will check that point. But the point I wanted to make is paragraphs 70, 71 and 72 of this judgment. The respondents rely upon paragraph 70 because they say that this case was an application of the Hills rule after the introduction of the pilot. I would make only this point, that it is clear from paragraph 71 where the judge says it is clear, and I underline accepted, that the attempted service was not valid service in that the claim form served was unsealed and lacked a claim number.
It was
That
conceded.
argument, it was conceded. There was no argument on that point in the case.
Yeah.
So our primary point, is that the claim forms, the amended claim forms that were served on the 17th of July in the present case were valid claim forms for the purposes of CPR 6.3 and 7.5. They were claim forms within the meaning of the rules, which is all that was required to be served, or in fact amended claim forms, and they were served within time, and that the judge erred below in holding otherwise in paragraph 58 of his judgment. Now, the second tier of argument, as it were, is that it appears that the respondents will argue that even if this is correct as a primary position, that the documents are to be regarded as valid claim forms within the meaning of the rules, they were not, and I quote, ready for service under the pilot, and so could not be validly served. And this is effectively what Visa says in paragraph 16b and 16c of its skeleton argument. I won't take you to it, but for your note, it's core bundle tab 10, page 136. They say, we, the appellants, wrongly allied the question of date of issue with the question of what is required to be served. They say the latter question, what is required to be served, is clearly answered by paragraph 8.1 of the practice direction, which says that a document is ready for service when it is sealed. And Mastercard, for the record, essentially makes, as I understand it, the same point at paragraph 25 of their skeleton argument. Now, You will recall, and if I could ask you to have open the pilot practice direction, which is at tab 25 of the authorities bundle, and paragraph 8.1 is on page 498, thank you. And I'm not sure how your additional, the additional authorities that I sent over yesterday afternoon, are organised, but if you could also have open, and I'd like to refer you to those documents which were sent to the court yesterday, essentially to show how the pilot has developed over time. And if I could ask you to turn first to what has now been put into the authorities bundle, I hope at tab 29. If you don't have tab numbers, it's page 509. And just, if you've got that document.
Yeah.
Just to tell you what that is a previous version, no longer in force, but the previous version of the pilot, the electronic working pilot, Practice Direction 5C, and that version was in force between 2010 and 2014.
That was because this was what was known as e-working,
Yes.
which was a predecessor to CE file, and which proved to be an unmitigated disaster.
Yes, Practice Direction 51.0 perhaps unfortunately retains the title the Electronic Working Pilot Scheme, but this is...
It's the e-working, so it was a different electronic filing system,
right.
which the court did pilot. He's just looking at my lord, but he will, I'm sure, confirm.
Yes.
And which was indeed, I mean, it just didn't work properly. So we didn't use it.
Right. But what is, my lord, I say, and it may be...
I'm not sure how much you get.
Well, technologically, it may not have worked as a matter of the system.
Yeah.
But what I think is important, and I'd like to take your lordships to,
Yes.
is the way in which it treated
Service.
and acceptance.
Yeah.
If you look at paragraph 3.3 of the PD5C, which is on page 512, 3.3 provides for automated validation of the claim form upon filing. So there is an automated validation, you see on paragraph 332. And once that automated validation has occurred, subparagraph 3, the form or document will be issued, sealed where appropriate, and returned to the person filing or requesting the issue of the same. And paragraph 631 on the opposite page, page 513, provides that when a claim form is received electronically at the address provided by the court, subparagraph 1, subject to the automated validation referred to in paragraph 3.3, the claim form will be issued, sealed, and returned to the claimant for service. So it would appear under this regime there was no acceptance stage in the scheme, which involved a check by court staff. And my Lord Justice Birss nods, just to make that point. If you look then at the policy paper that accompanied the introduction of that practice direction, which is at the previous tab, tab 28. This is a policy.
This is the policy paper that precedes the introduction of P5C.
Yes, that's right. That's dated
28.
tab 28. It starts on page 505. And you'll you'll see on page 508, it's dated November 2009. It's preceded the introduction of Practice Direction 5C. But you'll see, and I wanted to refer you to a paragraph on page 508, page 4 of the internal page numbering, the bullet point that says service of process. One of the key advantages of the electronic issue of claims is that it is fully automated, which can validate a claim form, allocate it a number, seal it and return it to the claimant for service without any interaction with court staff. Average time for completing this process is just under 6 minutes.
Well, that's what it says, but that's not what happened.
Right. But my lord, it would appear, and I make this point simply, that under the old Practice Direction 5C, it was envisaged that filing, issuing and sealing would be in effect simultaneous. It would replicate the experience of filing in person. There was no acceptance stage. That acceptance stage involving a check by court staff appears not to have been introduced until November 2015.
Well, that's right, because it's a completely different system.
Yep.
C-file is just a totally different IT system from the thing that this policy paper and your PD5C are talking about.
My lord, yes, I
There are
accept
electronic
that.
systems which automatically issue today. You can go on PD51R and you can automatically issue and seal, and you'll get a sealed claim form there for a small money claim if you're a litigant in person. You can use PD51S and issue a county claim, and you'll issue it automatically. So it is possible to do it. It's just that the C-file system doesn't.
Well, my lord,
As PD51O makes clear by referring to acceptance.
Precisely.
my lord, yes. We make the point simply,
But none of these things, whichever one you look at, none of them is predicated upon service before sealing. I mean, even this one says that you can validate a claim form, allocate it a number, seal it, and return it to the claimant for service. So true it is, it contemplates a simultaneous series of steps, if you like, but it still contemplates documents having been sealed before they're served, just as 8.1 of the practice direction we're concerned with does.
well, my lord,
So I'm not
yes.
sure how this helps.
Well, my lord, the point is simply this, that this practice direction, another form of electronic working, and I take the points your lordships have made about that, but it seeks in effect to replicate the in-person process which previously existed and does, and where those steps happen simultaneously. And we do say that there is an anomaly in the pilot under 51, Practice Direction 51.0, where there is this gap between filing, submission, and sealing. And we do say that it is in the nature of a pilot to test a system to uncover anomalies, but we say cannot have been the intention of a pilot, or the intention of this electronic working pilot, that the move from the old system to a new electronic way of working would, as it has done in this case, and I do make this submission, cause damage to claimants which they would not have suffered under the old system. I do make the submission that on the facts of this case, all the claim forms, amended claim forms, which were filed, submitted by 418 on the 17th of July would have been sealed under the old regime of someone walking into the court by close of court business. There was no question, none of them subsequently failed acceptance. So they would have been sealed by close of court business under the old regime. and therefore they could have been easily, I say, served before midnight by email, which was the agreed form of service, on the 17th of July. And the fact that they could not be was an unfairness, I say, or a damage that the claimants in this case, on the facts of this case and these appeals, would not have suffered under the old regime. And my lord, it's in that context I make my submissions on how this court should read paragraph 8.1. It is also provides the context for my subsequent appeals under 310. My subsequent submissions on the appeal under 310. So first, my submissions on para 8.1, you'll see that, and you have already seen, paragraph 8.1 of the practice direction says, the court will electronically return the sealed and issued claim form to the party's electronic working online account and notify the party it's ready for service. Now, in our submission, that simply says the court will notify the claimant's representatives once the sealed version is ready. It is not a directive which says you cannot serve an unsealed claim form if that is all you have. And we say it should not be interpreted in that way. If it had been intended to be interpreted in that way, it could have been drafted in those terms. We say that a reasonable reading of paragraph 8.1 in the context of this case is that if a sealed version of the claim form is not yet available for whatever reason, the claimants should serve the unsealed copy, and then once the sealed version has been returned, serve that sealed copy. And in fact, my lords, that is exactly what happened in the analogous situation of the appeals before this court. If I could take you to supplementary bundle tab 47. Yes, please, my lord. And if you have that supplementary bundle tab 47, is an exchange of emails. If you could turn to page 227 at the bottom of the page, and over the page, the substance of an email from my instructing solicitors to the Court of Appeal Registry. And this email was sent when we were serving the appellant's notice on the respondents. And of course, your lordships will be aware that the rule under CPR 52.12.3 is that an appellant's notice must be served on each respondent no later than 7 days after it is filed. And you will see the email at the top of page 228, which says we act for the appellant's notice were filed on the 30th of December in accordance with the guidance, the coronavirus guidance. As the court is aware, pursuant to CPR 52.12.3, an appellant's notice must be served on each respondent not later than 7 days after it is filed. The deadline for service of the appellant's notice is therefore today, the 6th of January. As at the time of this email, we have not yet received a sealed appellant's notice from the Civil Appeals Office. The 5th to 8th respondent's position, I think that's Mastercard, is that service of an unsealed appellant's notice is not valid service, and therefore our clients must apply for an urgent extension of time to comply.
Sorry,
What?
I'm sorry, I'm losing you as to where you're reading from.
I'm sorry, my lord. Start again then. At the top of page 228.
Top
It's
of
the
page
228.
228, thank you.
Sorry, as I lost your lordship, perhaps I could
No,
ask
sorry,
you to
no,
read.
I was looking at the wrong one. That's fine. Let me just.
I could ask you to read that email. That's an email from my instructing solicitor, 6th of
Yeah.
January, 9:05 in the morning.
Yeah. Okay, yes, I follow.
So, and the reply is received from the court office, the Civil Appeals Registry.
Serve the unsealed
Serve the unsealed
appendix.
and then serve the sealed when you get it.
Yep.
And we say that, in the circumstances of this case, is the approach that can and should be taken to the interpretation of paragraph 8.1 of the practice direction, and in any event should inform the court's approach if you do not accept that primary submission to the application under 310.
The email, page 227, is a direction by a Court of Appeal Master, isn't it?
Yes.
So, if you wanted to be philosophical about its legal effect, one thing it could be said to be is an extension of time.
Well, my lord, it's simply given as an example of a sensible approach.
Sure.
And we say,
Extension of time, or even, I suppose, an application is 6:15 even, actually. But within time.
well, my lord, that's not strictly what's said on the face of the email. I mean, the email simply says, don't worry, serve an unsealed, and then when you get the sealed, serve the sealed. But that's,
I think the point we're making is that it's not, even if that were, as it were, of any relevance, it's not the master's interpretation of the rules for service. It's the master giving you some leeway in the particular circumstances.
well, my lord, we say that this is an approach that is a sensible approach, and that we say in the context of 8.1, in the context of this case, and the wording of paragraph 8.1 allows the court to read the wording of paragraph 8.1 along those lines. And we say it is a reasonable and sensible interpretation of 8.1. That's our primary submission. Our secondary submission is it's a reasonable and sensible approach to be taken under 310.
I understand the point under 310, but I'm not sure.
Right. Well, my lord,
Well, I understand the point, but I'm not sure I accept it. Anyway, we will think about your.
my lord, I take that. I take that indication. Before I go to ground 2 and rule 310, I just want to make two final points under this first ground. The first point relates to the aim or objective of having to serve a sealed claim form, if that is how you interpret the rules. And this is the point that's made at paragraphs 20 to 22 of Mastercard's skeleton and paragraph 18 of Visa's skeleton. I'm not going to take you to it, but they make the argument that, although this was not considered by the judge below, the aim or objective of having to serve a sealed claim form is to provide assurance to the defendant that a valid claim has been issued against it. Or, and it's put in the White Book notes, paragraph 632, and I quote, being served with originating process by authority of the court, not such some informal demand. So you need to know that what you're being served with is not just something that's been drafted up by the defendants, has not been filed in court, submitted to court, issued by court. So you need a seal on the document to prove that. And our first response to that is that on the facts of this case, that's paragraph 58 of our skeleton argument. I've already made the points though, but they do bear repetition. The defendants, the respondents, had already been provided with, on a for information basis, they'd already been provided with copies of the original claim forms which were sealed and obviously bore claim numbers. Their solicitors had countersigned correspondence submitted to the court bearing the claim numbers in order to extend time for service, and the amended claim forms bore the same claim numbers as those original claim forms. So in each case, the amended claim form could easily be compared with the original sealed claim form which had previously been provided. And I've also made the point that the defendants were also served with detailed particulars of claim. So they knew the case that was being made against them in some detail, and they knew that the proceedings had been issued and sealed, and that subsequently the claim forms had been amended. The second point, and this is a point I make, that under electronic working, as the judge indicated in Dory, the CE filing system can show a defendant if a claim has been filed and issued, subject to the point I'm coming back to you on. The defendant's respondents are able to log on to the CE filing system and check for themselves whether the claim form has been issued. So that in itself provides certainty to the defendants, can provide certainty to the defendants. The provision of a original sealed claim form no longer is necessary to achieve that objective of certainty. The second and final point I want to make under ground 1 before I move on is the point made by Visa in paragraph 18 of its skeleton, 17 of its skeleton, and Mastercard in paragraphs 27 to 29 of their skeleton, which is that Mr. Justice Morgan's interpretation of the rules does not give rise to practical problems. And even if it does, the appellants have brought it on themselves by waiting until the last day to file. He said in paragraph 57 of his judgment there are advantages of electronic working, and as Mastercard puts it, the fact that there's a gap between filing and receipt of a sealed claim form does not justify obliterating the long-standing and clear requirement that valid service may only be effected by means of a sealed claim form. Just addressing each of those points briefly in turn, we do say that the approach taken by the judge below does cause real practical problems because of the time lag between filing, submission, and sealing and confirmation that the case has been accepted. It is the case that in the majority of cases, a claimant has 4 months to serve an issued claim form. So you could say, well, it's their problem then. They shouldn't have left it so late. So the fact that the registry may take days to provide a sealed claim form shouldn't cause any real practical problems because you've got 4 months. But there are cases, my lord, and this is why I say this appeal is of more general importance. There are cases, apart from the cases that are before your lordships, where the lacuna or that time lag created by the pilot will create real problems. And that's particularly so under those procedures where there's a very short timeline for service after a document has been filed. For example, the case of procurement cases. So in such cases, and I'll take you to the case of City Sprint, it's not the case, as Visa suggests in paragraph 17A of its SCELI, that it's only claimants who leave matters to the last moment that need to be concerned by this delay between filing and sealing. If I could take you to the case of City Sprint, which is a case under CE filing and is a procurement case. It's tab 23 of the authorities bundle. And before I get to the substance of the case, which I'll come back to in the context of Rule 310, that it's just worth explaining the timetable and the impact of the judge below's approach in a case like this. It's a procurement challenge, as you'll probably be aware. In such cases, the economic operator has to serve the claim form on the contracting authority within 7 days after the date of issue. So the claim form has to be issued, and then it has to be served within 7 days of issue. The procurement cases are also subject to the CE are subject to CE filing. Use the electronic working pilot. In that case, the claim form was issued on the 27th of July. The claimant solicitor served an unsealed, but it's described as issued, but I take your point, the filed claim form on that date, the 27th of July. However, there was some confusion about the amount of the court fee under the CE filing and boxes that could or could not be ticked on CE filing, which meant that the claimant solicitors had slightly underpaid the court fee by about £500. They paid £10,000 rather than £10,523. And so the claim form failed acceptance on that basis. The correct fee was paid, and the court claim form was then sealed on the 29th of July. However, the claim form did not change in form. Obviously, it was just a question of the court fee. The claim form was sealed on the 29th of July, but not received by the claimant's solicitors until the 30th of July. But of course, because of the rules under CE filing, it was held to have been issued on the 27th of July. So the claim form is issued on the 27th, sealed claim form not received by the claimant solicitors until the 30th, but due to the procurement rules, had to be effected. Service had to be effected by the 3rd of August.
Yeah.
And so that wasn't done. The claimant solicitors mistakenly calculated the 7 days as running from the 29th of July when they'd been notified that the claim form had been accepted, although they didn't get the sealed version until the 30th. And so they served the sealed claim form 2 days late. I'll come back to the analysis of the judge in that case under Rule 310, but I refer to it now because it shows that real difficulties can be caused by the gap in time under the pilot between the date of issue and the date on which a sealed claim form becomes available for service. That is, we say, a potential problem under the e-filing regime, which has been highlighted by our case and also in this procurement case. Mr. Justice Morgan's answer to this was, well, that might be the case, but there are obvious ways in which electronic working is superior to the previous system, paragraph 57 of his judgment. That's, of course, accepted. There are obviously benefits, but those benefits arising from the convenience of being able to file, submit outside court hours should not come, we say, at the cost of certainty, and the potential problems in the pilot, the lacuna, however you want to describe it, that's highlighted in this case, and will also cause problems in other cases, such as procurement cases, we say should be addressed by the court. We say either under our first ground, which is the interpretation of the rules, and paragraph 8.1 of the practice direction, or under our second ground, which is our application under Rule 310. So moving then to our ground 2. Moving then to our ground 2. That, of course, is made in the alternative to our ground 1, and only becomes relevant if the court, if our challenge fails on the basis that the court below was correct to hold the unsealed amended claim forms were not validly served on the 17th of July. Now, Mr. Justice Morgan held, as you'll be aware, that Rule 3110 was not capable of applying at all in the circumstances of this case. So he did not go on to consider whether or not to exercise his discretion under 310 or the facts relevant to the exercise of that discretion. He reached that conclusion on the basis of 3 Court of Appeal judgments in Vinos, Elms and Steele, which he read as holding that Rule 310 is a general provision which can't prevail over specific rules as to the time for or manner of service of a claim form. That's paragraph 87 of his judgment. He also held that what he described as obiter comments by Lord Brown in the House of Lords in Phillips and Symes, to the effect that the court could order under 310B defendants to be regarded as validly served as an alternative to dispensing with service under Rule 6.9, which is now 6.16, could not overrule the ratio of those previous decisions of the Court of Appeal. And he looked at various first instance judgments, Integral, Baroda and Dorey, and decided to follow the judgment in Kiepenbrook. Now, Mr. Justice Morgan granted permission to appeal on this ground on the basis that the authorities at first instance are in a state where a ruling of the Court of Appeal would be welcome. And so I will take your lordships, your ladyship, to those cases. Our submission is that the judge below was wrong to hold that Rule 310 wasn't available to him as a matter of principle. And we say the case law does not prevent Rule 310 being used in a case such as the present to retrospectively validate defective service. And we make that submission on this basis. There is a distinction drawn in the case law between taking a procedural step defectively on the one hand and on the other hand, either omitting to take that step at all or performing a step in proceedings which is directly contrary to the rules. We say that the case law makes it clear that Rule 310 cannot be used in the latter situation, but can be used in the former situation. And we say the former situation, that these cases fall within the former category. An error in procedure or a procedural step has been taken defectively. And so Mr. Justice Morgan was wrong in holding that Rule 310 was not capable of applying in this case. If I could take you to the Court of Appeal judgments that he relied upon. First of all, in the Authorities Bundle, tab 3, the first case, and I'll try and deal with these relatively briefly. They're all cases, previous cases of the Court of Appeal, previous judgments of the Court of Appeal.
Yeah.
The first case is at tab 3 of the Authorities Bundle, Vinos, and Marks and Spencer. Just a summary of the facts of that case. A claimant, Vinos, served the claim form 9 days after the 4-month period for service expired, simply, and I quote, due to an oversight. The claimant made an application to extend time under Rule 763, which failed, and the court held that CPR 310 was not available. So the facts of that case were that the claimant simply failed to serve any claim form within time, did not serve a defective claim form within time. And if I could ask you to turn to paragraph 20 on page 26. And ask you to read from H, at the beginning of paragraph 20, through to B on the next page. And what we say the ratio of this case was simply that Rule 310 could not extend to enable the court to do what is specifically forbidden, in the words of the judgment, by Rule 7.6. All this case shows in our submission is that where a claimant omits to take or fails to take a procedural step at all, so no service within time, or performs a step which is directly contrary to the rules, they cannot avail themselves of Rule 310.
I suppose you'd say it's the difference between Birss, which is a case where the claimant had not served anything, and therefore, by definition, needed an extension of time to validate anything that they did, as opposed to where you have served, albeit the service is defective. So what you're asking the court to do is not to extend time for service of the claim form, but to validate the defective service, and therefore it's not forbidden by 7.6. Is that your
Exactly,
case essentially?
yes. Moving then, my lord, to the Court of Appeal judgment in Elms, which is in the next tab, Authorities Bundle tab 4. This is the second Court of Appeal judgment that was relied on by the judge below. And in paragraph 10, which is on page 33, judge distinguishes between the instant case and the two cases which are Venus and previous, core. Thank you. In fact, there was service of the proceedings in time. And so the argument is made that the claimant doesn't need to escape the consequences of being unable to obtain an extension of time. He needs only to be allowed to have the service, deemed nevertheless to have been good service. For this, as stated, he goes not only to 310, but also perhaps more particularly to 681. 68 is then set out in following paragraph, and 69 in 11. Those now are 615 and 616. Now, there is a fundamental difference between 68 as it then stood and 615 as it now stands, and that is under 68, as you'll see from page 33, the application for permitting service, let me get this right, but by an alternative method cannot be made, as the judge described it in paragraph 13, retrospectively. So as he says at paragraph 13, on page 34, the fatal flaw in the argument is this, that's about 4 lines in to paragraph 13. It necessarily implies the argument that Rule 6.8, the rule which provides for service by an alternative method, can be applied retrospectively. If one asks what order the court is to make to rectify the mistake, it can only be an order under 310, that an order for alternative service not in fact made under 6.8 shall be deemed to have been made. But the plain fact is that no Rule 6.8 order was here made, and of course there was never an application for alternative service, let alone for an order dispensing with service. So, my lord, that is the basis upon which...
So it's asking, as the rule then stood, it was asking the court to sanction something that was expressly forbidden or not permitted under the relevant law.
That's exactly the point, my lord. The difference now, however, so it's the retrospective application of Rule 6.8 as it then stood. So that now, of course, Rule 615, CPR Rule 615.2 allows an order for alternative method of service or alternative place of service to be made retrospectively, in effect. The court may order that steps already taken are good service.
Is that? We've got 615 in the bundle.
Yes, it's on page, tab 24, page 483. So we say the ratio of the judgment in Elms is simply that Rule 310 cannot be used to enable a party to take a step which is directly contrary to the rules, that is, to retrospectively apply, as it then was, Rule 6.8. Now, it also should be noted, my lords, that the judge in Elms who gave that judgment was Lord Justice Simon Brown, as he then was, and he then went on to make the comments in Phillips, which I will, when he was a member of the House of Lords, which I will refer to. So one also needs to bear in mind that it cannot reasonably have been said not to have been, seen the judgment he gave in that case, in my submission, as being inconsistent with what he subsequently stated in Phillips.
And you haven't included the whole of the White Book citation.
No,
rule.
I know that, yes.
Don't worry, I'm not criticising, but if you look at the note at 615.5, retrospective operation, it says paragraph 2 of Rule 615 is designed to remedy what were thought to be defects in the law as it stood before the 1st of October 2008, points illustrated by Elms.
Right. I should have looked in the Bible rather than rely on the photocopies, yes.
I only do that because I've come across this point before for some reason. Yeah, okay.
And then the final court of appeal authority that the judge relied on below was the case of Steele, which is in the authorities bundle tab 6. I think we can deal with that before lunch, easily actually, I hope. So the judgment is at tab 6.
Yes.
And just to cut through, this was a personal injury case. A claim form was issued on the 6th of May 2003. That was 3 days before the limitation period for personal injury claims expired. Claimant's solicitor drew up consent orders extending time for service because she was unable to get an expert in the 4 months required. So she drew up consent orders extending the time for service. Those orders were made in the agreed form by the court, but the draft orders she drew up mistakenly did not refer to extending time for service of the claim forms. They only referred to extending time for service of the particulars of claim. So the orders on their face were in error, or did not do what they needed to do. So the claimant applied under Rule 310 for rectification of the errors in those orders. Now, the judgment of Lord Justice Dyson, I can take you to start at paragraph 14 on page 74. You'll see at the bottom of that page, 74, on it there's a heading CPR 76, which is the provision for extending time. I won't read it out. Paragraph 15 on the following page, he considers the case in Vinos. And then on page 76, over the page there is a discussion at the top of that page at sideline B, under the heading, what is a procedural error? And if I could ask you to read paragraph 19. So this is, in effect, the first question, was there a procedural error? And the second question is, was it forbidden? And then on paragraph 24, he moves on to the point that he makes the point which we rely upon. The general language of Rule 310 cannot be used to achieve something that is prohibited under another rule. And he says that's the principle established by Vinos. We respectfully agree with that. And then that is, we say, consistent with our argument about the two different types of procedural error. Under the heading does rule that then follows, which is, does Rule 763 preclude a remedy under Rule 310? There are various arguments about how to characterise the error on the facts of that case. And he comes to a conclusion on page 78, between A and B. Page 78, between A and B, and we rely upon this. There is a difference between A, making an application which contains an error, and B, erroneously not making an application at all. It is important for a proper application of the Vinos principle to bear this distinction in mind.
So what they were actually asking to remedy here was the defect in the consent order.
Yes.
The drafting defect, and,
Yeah.
and that's clear from what he says at 20.
Yes.
And that's the point he's picking up, isn't it, in 27? So he's saying what actually... So this case didn't fall foul of the VISA principle, because they weren't asking for an extension of time.
But
They were asking for the remedy in the consent order to be rectified. The remedy having been rectified, the extension of time came through the consent order, not through 7.6.
exactly, my lord. And we say that similarly, there was a error on the face of the draft order, or the face of the order, in fact, that was made by the court, which meant that time had not been extended for service of the claim forms, because the claim forms did not appear on the face of the order. But the judge, Lord Justice Dyson, clearly said, and we rely upon that this was not an extension of time by another name. This was the rectification of an error under Rule 310. A difference between making an application which contains an error and not making an application at all. And we say that is on all fours with our case, where if you accept that the claim forms served on the 17th, the amended claim forms served on the 17th of July should have borne a seal, that was a failure to comply with the practice direction, paragraph 810 of practice direction 551.0, akin to making an application which contains an error, serving a claim form, an amended claim form, which on its face contained an error, rather than not making that application at all, not serving a claim form at all. So, now the respondents may say, well, he didn't serve a claim form at all. The claim form should have had a seal on it. But that's exactly the same as what the argument that was being made in Steele. There wasn't an order for it, there wasn't an order extending time for the claim forms because the order didn't say claim forms on it, it only said particulars of claim. So, but we say there is a difference which is recognised in the Court of Appeal authorities and which applies to the facts of our case, which means that these authorities do not support the judgment below that 310 was not available as a matter of principle in the circumstances of the present case. So in effect, that could be it on our ground too. That properly read, these Court of Appeal judgments do not support the judgment below. They support an argument that in principle 310 could be used on the facts of our case.
On the basis that what the error of procedure that you're asking to be remedied is the failure to comply with paragraph 8.1 of practice direction 51.
Yes.
So it's not seeking an extension of time for the service, the valid service that took place later.
Yes.
Yeah, I see.
Your Lord, my Lord, I'm aware that we're now on 1253. I was going to take your Lordship to the House, the Court of Appeal and the House of Lords judgments in Phillips.
You're going to go to Court of Appeal in Phillips, aren't you?
My Lord, yes, which was, of course, set aside by the House of Lords, but it's worth just looking at what...
Is that Council's code for saying, please can we rise now and start at
Well, no, it's Council's code for saying I'm in your hands, my Lord. So whether you want to continue for another 5 minutes, but I'm likely to have to stop.
Start at 5 to 2.
Yes, my Lord, I'm grateful. Thank you.
Thank you very much.
Court rise.
Turn the live stream off.